Okay, well, welcome to this Aspire Australia client information session about the changes to the employment visa program on 18th of March 2018. I'm Sarah Gillis, Principal Consultant at Aspire Australia, and thank you for joining me today. As you know, we take our clients on a journey through the whole migration progress, starting with advice, going through preparing the application, dotting the I's, crossing the T's, celebrating your success. And we don't let it stop there. So we try and keep you in the loop so that any changes that may affect your current or future sponsorship needs are made aware to you. So today we're looking at how the 18th of March changes may affect your existing staff and future options for those and new staff. The 457 program has been replaced with a 482 program, similar in structure, but what we're going to look at is what has changed in the new program. We're going to demystify some of the terms that will be used as part of that program, including LMT, TSMT and AMSA. And we're going to look at what pathways remain available for your 457 or 482 visa holders for permanent residence. So you may recall that the 457 program had three elements to it: the sponsorship, nomination and visa. Now that same structure continues under the 482 program, and you'll be pleased to know that the sponsorship has now been streamlined and simplified. No longer is it a requirement to have show training as part of the sponsorship, which means that as long as the business is operating, as long as the business is operating and there's no adverse information on Department of Immigration files, there will be a streamlined process for sponsorship. So approvals could come within a couple of days or even a couple of hours or a couple of minutes, especially for renewing sponsors. All sponsors, whether they're new businesses or existing businesses, will get a 5-year umbrella sponsorship approval, which again standardises the whole process. So 482 sponsorship should be fairly straightforward from now on. But where the engine room of all the changes is in the nomination. So the nomination is all about the position and the position within the company. So there have been a lot of changes here. Some of the key changes are that the position must be a full-time position. Previously, depending on the industry, it could be possible to have less than 38-hour-a-week position if that was the industry norm, but now the positions must all be at least 38 hours full-time work. It will still be possible to transfer workers who have an existing 457 or 482 visa. Now, previously, the company would just lodge a nomination and would get priority on that transfer from company A to company B. And that priority would mean in most cases the approval would come through in about 2 days, and as soon as the nomination was approved, the visa applicant could start working for your company. That's changed slightly now and will lead to some delays. So if your company is taking an employee from another sponsor, not only will the nomination need to be lodged, but a new visa application will also need to be lodged. So this is regardless of whether it's the same or different position, the candidate would need to apply for a new 482 visa. Now, just a little note, this doesn't apply to people that are currently holding 457 visas. So right at the moment, you know, the most of the workers out there will be holding 457 visas. So if one of them comes on board, you can still just lodge the nomination. But as soon as 482 visa holders become common in the marketplace and you're selecting one of those to work for your company, you need to realise that a nomination and a visa will need to be lodged. Now, current processing times for 482 visas and 457 visas is in months, so it could be 2 or 3 months. So this is going to lead to a delay in the candidate starting work for you. So that needs to be examined at the time you select the people, so you know how that's going to affect your business. Now, just as under the 457 program there were occupation lists, that continues under the 482 visa program, and it's now entrenched in law that occupations on the different lists have different visa periods. So there's a medium and long-term list, and there's a short-term list. So where a company selects to nominate someone in the medium and long-term list, you'll be rewarded with a 4-year or up to 4-year visa for that candidate, and that person will have permanent residence options under the employment program later. But if you choose someone under the to nominate someone under the short-term list, they'll initially only get a 2-year visa. Now, that will be renewable onshore for a further period of 2 years, and it can be renewed offshore for a further period of 2 years. So you can obtain that worker for up to 6 years, but you will need to go through the process every 2 years to renew their sponsorship. And as we go through the other elements of the nomination, each of those factors will need to be redone at each 2-year mark. And those candidates on the short-term list will have no pathway to permanent residence under employer sponsorship, full stop. Now, the medium and long-term list mostly covers professionals, so medical professionals, lawyers, doctors, dentists, IT, and also a number of trades and some management occupations. The short-term list would cover occupations such as finance, marketing, HR, restaurant managers, other smaller managers, and a number of trades. So when looking at sponsoring someone, we need to make you aware of what visa period you're going to be looking for those candidates, because that will, if you're filling a need in your business and you think that's a long-term need, there may be other strategies required to retain that person on a permanent basis. Now, the next key change is in relation to the employment agreement. It's always been a requirement that an employment agreement is provided. However, there's an added requirement now that the sponsoring employer must certify that the employment of the nominee, as evidenced by the employment contract, is in complete compliance with all federal and state industrial laws. So for those of you who are HR managers or advisors, you'll be in a position to ensure that is correct. For those that are perhaps business owners, you may need to consult an HR professional to get that certification and to ensure that the employment agreement is compliant. And the final key change for the 482 is the introduction of a training levy, which I'll go through in more detail. So training was always a part of the previous 457 program, but it was a sponsorship requirement, and you needed to show that you'd spent 1% of the gross payroll on training Australian staff, or you'd invested 2% into an industrial training fund. That has now been removed. So instead, there is the replacement of the Skilling Australia Fund. Now, just to let you know that this has not yet become law, so it is stuck in Parliament, and later in May 2018 it will be brought up again for discussion in Parliament. The proposal at this time is that every time a company lodges a 482 nomination, the levy, the training levy, will be payable. So if the business's turnover in the preceding year has been less than 10 million, then the levy will be $1,200 for each year that you plan to have the nominee. So if you've nominated someone as an accountant, say, that occupation's on the medium and long-term list, so you're entitled to nominate them for 4 years. So the levy in that scenario would be 4 times $1,200, so $4,800 would be payable at the time of lodging the nomination. So it does provide some clarity as to whether a company meets the training requirements or not, because you won't be able to lodge until the payment is made. However, there will be situations where a person doesn't work out their 4 years and perhaps leaves after 2 years. There will be refund provisions. At this stage, they are not very clear about how those refund provisions will work, and it seems to be a bit of a paperwork nightmare that the department is creating for itself. But just to say that that's what the landscape's going to look like. Now, right at the minute, training is not required for sponsorship, and the Skilling Australia Fund levy has not come into effect, which means that companies right at this minute can lodge nominations without paying anything for training. So if you have someone that you want to nominate shortly, the sooner you can get that lodged, the better, because by the end of May, this training levy may have come in. So you can save yourself some money by lodging those nominations now. And I'll let you know a bit later how you can keep up to date with knowing when these changes come in. For businesses that have a higher turnover, there's a higher levy as indicated there. Another new requirement for the 482 is labour market testing. Previously, this had limited application, but now it will apply to every nomination that is lodged under the 482 program, unless there is an international trade obligation applying. So if there is a free trade agreement or some other negotiated agreement with another country, then labour market testing may not be required. That will be in that exemption will be in a very limited number of cases. So for the majority of cases, labour market testing will be required. The labour market testing must be undertaken within the preceding 12 months. From July this year, that will be shortened to labour market testing being required within the preceding 6 months. So what is labour market testing? The requirement or the reason why labour market testing is there is that the government wants to make sure that Australians are being given opportunity and first opportunity for jobs. So the labour market testing results would need to show that there is no suitably qualified or experienced Australian readily available to fill the nominated position. And unless you can show that, then you can't nominate the candidate you have in mind. The law doesn't specify how that labour market testing should be undertaken, but the Department of Immigration have developed their own guidelines, many of which go beyond the legislation and in a court of law may be considered ultra vires. But at the moment, that's the guidelines that Immigration have given, and they expect companies to apply. So those guidelines include placing the ad in a national newspaper and placing the ad in an online program, for example, Seek or Adzuna or any of the online portals, for a period of at least 21 days. So the changes there are that labour market testing was not previously required for all occupations, and when it was, you could advertise locally. Now you're expected to advertise nationally and filter through those applicants to find out whether there are any Australians that are suitable for the job. In fact, Australians or working holiday makers or New Zealand citizens. So the repercussions of this are that, first of all, you may find an Australian candidate that's suitable for the job, in which case, you'd be expected to employ that candidate instead of the 482 nominee. The other is the lead time. So if you are going to comply with the Department of Home Affairs policy and advertise at least for 21 days, then it's going to take longer to get your nomination lodged. So if you want to do something quickly, there will be actually some delay. And if you haven't already found your candidate through labour market testing, then you're going to spend 21 days advertising, then sifting through those results, showing that there's no Aussie available before being able to lodge the nomination. So, of course, here at Aspire, we'll help you with drafting the advertisements and making sure they're meeting with the department's policy, and also helping you to provide the information as to why the candidates are not suitable. Now, again, the government has given companies the ability to nominate workers from overseas where there aren't Australians available, and to employ those workers on terms and conditions that are equivalent to what an Australian would achieve. So one of the, and this will all be shown in the employment contract. So a new guideline has come in relation to this, and it's the annual market salary rate, or AMSR. Now, you can see from this little diagram that I've done for myself to help understand this, that it's not simple. The basics are that the 482 visa holder should be paid a salary that allows them to live in Australia. And that salary is based on the TSMIT, so the Temporary Skilled Migration Income Threshold. It was existing in the 457 program, and that TSMIT is currently set at 53,900. So the statisticians have said that's the minimum livable allowance in Australia. So if what you want to offer your 482 nominee is less than the TSMIT, it cannot be successful. But there are other factors to be considered as well. So do you have an Australian in a similar role? Is there an award that applies? And is the award above the TSMIT? Most awards, many awards, the majority of awards don't have a base salary that is above TSMIT. So that can be an issue. Are there any monetary or non-monetary benefits that will be offered to the nominee? And if any of the above don't apply, is it reasonable to disregard them? So, for example, let's say there is an Australian in a similar role, and that Australian's being paid $55,000. Now, if there is an award that applies, that's the first thing immigration wants to look at. If under the award the salary is actually $45,000, then that is not above TSMIT and it can't be successful. The only way it could be successful is if there are additional non-monetary benefits being offered to the candidate, for example, allowances for accommodation or cars or other benefits, or you can prove that it's reasonable to disregard. So in the case where you're paying the Australian $55,000, you can argue that the award is low, it's not what is actually the real life market salary that would be offered to an Australian, and here's an example of an Australian getting above award rate. Now, the Department of Home Affairs hasn't got a whole lot of policy, and we haven't had a lot of decisions on this, obviously, already. So we need to watch this space a little bit. In the meantime, we need to make sure that the base salary is above the TSMT, that we're comparing it to real life jobs, whether already existing in your company with an Australian working in there, or we can find external data that shows that the salary is at TSMT and also above award. And we can also explore and add on any non-monetary benefits. So if we can work out the value of those, we can add that on to the base salary to make it either above the TSMT or above the award. And we can also put forward submissions to the department to say it's reasonable to disregard any of the factors that haven't been met because this is what your company does offer in terms of salary packaging. So a little bit complicated, but I guess the bottom line is the TSMT is the minimum threshold, 53,900. Above that, we can probably, and if there's an award that applies, we can probably raise some argument and submission with the department. But we'll talk about those one-on-one when you have a case that arises. Now, you will be aware that previously sponsors could not recover the cost of sponsorship from their nominees, and that included any Department of Immigration fees or migration agent costs or recruitment costs. That has now been expanded in law to cover any costs in relation to the nomination. So the nomination is about the position. So those costs can't be transferred or recovered from the nominee. So sponsoring companies must pay for any costs in relation to the nomination. That includes the Department of Home Affairs lodgement fee, currently $330. That will include the Skilling Australia Fund. That will include migration agent costs. That will include labour market testing costs, the use of recruitment consultants, and any other costs involved in getting a nomination approved. So that fee can no longer be passed on or shared with the nominee. There will be penalties, from pecuniary penalties to imprisonment for multiple offenders. So just to keep that in mind when considering the cost of nominating someone, that both the sponsorship and the nomination costs will be payable only by the employer. Now, the 482 visas, there have been some changes here as well. One of the main changes that will affect companies is that every visa applicant must have at least 2 years experience in the occupation before being nominated. So this now excludes any recent graduates from being sponsored under the 482 program. The 2 years experience is expected to be post-qualification, if the candidate holds a qualification, full-time experience in the occupation. So where a candidate doesn't have that experience, they won't meet the visa criterion. So it's important before even starting the nomination process to make sure the visa applicant has that level of experience. The second requirement is that many more occupations require by law a skills assessment. This mostly covers trades, but also some paraprofessional occupations. Previously, under the 457 program, it was just policy that a number of occupations where candidates came from certain countries would require skills assessment, but this has now been codified in law. So for those occupations, it will be mandatory. There is a long list. It is mostly trade occupations, for example, cooks and carpenters from certain countries. Again, we'll advise you about that when you're considering nominating someone. Now, the skills assessment process can be lengthy, can be costly, and requires quite a bit of documentation to be provided. So where a skills assessment will be required by law, we would highly recommend that you as the employer require the candidate to get that positive skills assessment first before you start the process, because if it's not positive, they won't be able to proceed. As I mentioned in relation to the nominations, depending on which occupation is being nominated, the visa applicant will get a visa for the relevant period. So if the occupation is on the medium and long-term list, they'll get a visa for up to 4 years. If it's on the short-term list, it will initially be for a period of only 2 years. And as I mentioned, those candidates on the short-term list will not have a pathway to permanent residence from the 482 visa, but still there's an added requirement for them to show that they are a genuine temporary entrant, so that they have no illusions of obtaining permanent residence at the end of it. The genuine temporary entrant has been a criterion in the student visa program and has long been a ground for refusal of visas. So it will be interesting to see how deeply the department wants us to go in relation to this criterion, especially given that that candidate doesn't have the pathway to permanent residence in any event. But it will be a requirement and it should be addressed at the visa stage. So you have your candidate sponsored on a 482 visa. What are the options for permanent residence? As I mentioned before, only those 482 visa holders with occupations on the medium and long-term list will be eligible for permanent residence. So if you've sponsored them on a short-term list, or if the occupation changes list during the period of their employment and it's no longer on the medium and long-term list, then permanent residence will not be available. There are still the two pathways to permanent residence through employer sponsorship. There's the transitional, where the person works on the 482 visa, and then there's the direct entry. For the transitional, the period used to be 2 years. It has now been extended to 3 years. So the 482 visa holder would need to work with the employer for 3 years before being eligible to transition to permanent residence. Companies will now need to show their financial capacity to employ the person for a further period of 2 years. And this has been the basis for many recent refusals by the Department of Immigration, i.e. financial capacity. So many of those decisions have been based on incorrect interpretation of the financial data. So it is important for employers to clearly provide evidence of their financial capacity, and where there might be something questionable on the balance sheet or the profit and loss, that is explained in detail. Now, whilst training is no longer a requirement for 457 sponsorship, it is still an obligation of the company to have met its sponsorship requirements in relation to training or sponsorship obligations. So when it comes to permanent residence, that will be audited by the Department of Immigration. Now, as time goes on and the 457 employees transition into 482 and you no longer have those, that compliance requirement will dwindle away. And as soon as the Skilling Australia Fund levy comes into effect, any current sponsorship compliance obligations will no longer be in effect. So if you have a sponsorship that has an anniversary in, let's say, July, if the Skilling Australia Fund comes into effect in June, then you will no longer have an obligation to meet your sponsorship requirement of the 1% or 2% in that July period. Instead, whenever you lodge a new nomination, you'll pay the Skilling Australia Fund levy. Now, at permanent residence, as I say, they will still check that you complied with in the years that you were required to comply in. And also, just as for the 482 nomination where there is a levy under the Skilling Australia Fund, there will be one for permanent residents as well. So the figures are there, $3,000, just a one-off payment if the company's turnover is less than 10 million, or $5,000 if the turnover is greater than 10 million. Again, as that Skilling Australia Fund has not come into effect right now, that is not payable right at the minute. So if you've got the option of nominating someone right now, then you can do it without having that levy payable. The main thing for the main change under the employer nomination scheme is that occupations must be on the medium and long-term list, regardless of how that person is coming to permanent residence with you, through the transitional or through the direct entry, then the occupation must be on that list. For the visa applicants themselves, again, regardless of whether they're coming through direct or transitional, they must have 3 years experience. The age limit has been reduced from 50 to 45 years. So that is a major change that will affect a lot of senior people within companies and managers. Now, there are some transitional provisions for 457 visa holders who had a visa at 18th of April 2017, or who had an application for a 457 visa on that date and they were later granted the 457 visa. So that transitional group can still use the old law to apply for permanent residence. So that means it doesn't matter what their occupation was if they're coming through the transitional program. They can still be up to age 45 and they can apply after 2 years on the 457 or 482 visa with the company. So those people, when they had their visa granted or issued last year, had certain expectations for moving forward to permanent residence. So they have been allowed to continue on that same pathway, and most of your 457 nominees that you have at the moment would be part of that program. For anyone that's not in that transitional group, they will need to meet the new criteria. Now, there will be a large number of candidates who've been sponsored who don't have that pathway to permanent residence through the employer sponsorship, but they may have other options for permanent residence without the company's sponsorship. They may be eligible for general skilled migration. They may be eligible for a partner visa. So for those that you want to retain but you're not able to nominate them for permanent residence, we can explore those other options. So in summary, the main changes are that there will be a training levy applicable for all nominations that are lodged after the Skilling Australia Fund legislation is introduced. That all 482 positions must be advertised for a period of at least 21 days before the nomination is lodged. And there are increased work experience requirements, both for the 482 visa, where the candidates require 2 years work experience, and for permanent residents, where they now need a minimum of 3 years experience. And there are limited pathways to permanent stay. So for candidates on 482 visa with occupations in the short-term list, you will have a maximum of 6 years life out of them unless you can find an alternative pathway for them that's not related to employer sponsorship. And all of these changes will affect your planning, and we'd be happy to help you in that regard. So we know that the biggest challenges for you as an approved sponsor are not knowing what you don't know and keeping up to date with the changes. So as always, we've got you covered, and there are two main ways that you can keep up to date with these changes and get the advice that you need. Number one is by joining our sponsorship boardroom, which we have transitioned or are transitioning from the Facebook platform to the LinkedIn platform. So you've got the LinkedIn group details there, which you can copy down, and we will email that to you after this presentation as well. So we will be putting any updates in there, some information. We'll be updating all the tools and resources that we had in the Facebook group that related to 457. We'll be updating those for the 482 so that you can use those as a quick reminder about what the requirements are. But of course, as always, please speak to us about your needs so that we can give you advice about your specific scenario, because there are so many factors that are going to affect you, and we want to make sure that you get the right advice first time. So you can email for an appointment to talk to me, or you can just pick up the phone and give me a call. Carol is there ready to take your call and make an appointment. So I invite you to contact me and talk about your specific situation, and we will get through this together and make sure that you're still attracting the skilled workers that you need and retaining them for as long as both you and they want. So thank you for joining me this morning. Just a quick summary for you. And as I said, we can talk more on a one-on-one basis online. So thanks again, and I'll talk to you soon. Thank you.